Mr. Bates, have you sorted out between yourselves, are you going to deal with both matters up front, or are you swapping over between you?
So we envisage a fair bit of swapping around, if that's more convenient. The plan, to my learned friend, is that I'll open the case and make the submissions on the appeal.
Yes.
And I've got a hard stop of 1 hour 45 minutes for that.
Yep.
My learned friends then respond on the appeal and make their substantive arguments on their respondent's notice.
Yep.
And they have a hard stop of 2 hours and 5 minutes to do all of that.
Yep.
We'll then respond on the appeal, the final word on the appeal, and reply on the respondent's notice, and we have a hard stop of 1 hour and 5 minutes, and then my learned friend has the last word on his respondent's notice.
Yep.
Which takes us to, we think, 4:30 hard stop.
Okay, we'll be very pleased if we finish earlier than that, not least because my own personal practice is normally to try to finish by 4:15.
In that case, then, I suspect we can all find a way of slicing off some time as we go along.
If you chess clock running.
Well, a hard deadline is something to keep in mind, but not necessarily a target to aim to. I think is the answer there. So if that meets with your approval, then my lords, you should know from the material we submitted earlier in the week, I appear with Miss Gibson for the appellant landlord, and my learned friend, Mr. Jacobs and Miss Sparks, appear for the respondent RTM company.
Yes.
As you know, like canvas from the exchange there, we have both an appeal and a respondent's notice to deal with. On the appeal, the critical question, it seems to us, is what's the consequence of the respondent RTM company having failed to serve notice on a qualifying tenant? Because we assume, for the purposes of the appeal, that she is a qualifying tenant.
Yes.
And that then breaks down into two sub-questions. Firstly, does the Act itself provide a consequence? And if not, then it's the Synergy approach, as recently reaffirmed by the Supreme Court in the Avon Properties case. Now, we say there is a consequence. We say it's Section 79.2. And if we're wrong about that, we say Synergy gets to the same result. My friends, of course, say we're wrong, and their respondent's notice is another reason why we would be wrong, which is they take the more fundamental point that they didn't need to serve this appellant in the first place. In terms of dividing the advocacy on this side, we're planning to split it on this side. The plan is that I'll deal with the appeal and some of the initial policy arguments on the respondent's notice, but the bulk of the respondent's notice will be dealt with by Miss Gibson. Mr. Jacob will be doing all of the advocacy for the respondent.
Yeah.
I hope that meets with your approval.
Yes.
What I would like to do, I appreciate that you've had the bundles for some time and you've had the skeleton arguments, but I also appreciate you've been sitting as a constitution all week with other matters to deal with. So I will open the facts relatively shortly because it's not a fact-heavy case, but just taking you through the key passages in the FTT and Upper Tribunal's judgment. I'll then spend a bit more time doing the scheme of the Act as a whole, because I know that I've appeared before my Lord on some of these cases before, but this may not be uppermost in my Lord's mind, and I don't know if either of my other two Lords have ever come across this regime before, so I'll take you through the provisions and then move on to the grounds of appeal. There is, as you will have seen, the reality is there's a large amount of overlap between my grounds 1, 2 and 3. One could quite fairly say that grounds 2 and 3 are simply another way of putting ground 1. So I may not cleanly salami slice in that way. If you take the view there's a consequence, it doesn't matter whether you find it under ground 1, 2 or 3. Ground 4 is slightly different, but I'll deal with that very shortly. It's very much my fallback ground.
Yeah. I mean, is it an oversimplification to say that on grounds 1 and 3, your one sort of big point is simply that on the proper construction of the legislation, it provides for the consequence that follows from failure to serve a notice on Mr. Joseph?
That is not an oversimplification at all, and I am very grateful that our skeleton argument has made that sufficiently clear to have been grasped before I start speaking.
That impression has come through firmly. Whether it's right or wrong, of course, is the key point we will have to decide.
Well, it's certainly the impression I wanted to convey, so I'm glad it achieved that purpose, if nothing else.
Well, Mr. Jacob will tell us that's a false trail, I'm sure.
My learned friend and I have been regular sparring partners in almost all of the cases we'll be looking at today, so suffice to say this is yet another one in which we disagree on just about everything one can disagree upon. So with that introduction out the way, can I then move to the factual position in this case? And we'll start with the FTT's decision, which is at page 104 of the core bundle. And you see from page 104, from the top at the case references, that there were 6 cases being heard together at Hill Court and Cresta Court. And that's because over the page at 105, under Decisions 1, there was a different RTM company for each of the different premises to which the Act applies. This is, we don't have any photos of it, but you can imagine this is a fairly modern development. It's essentially it's a T-shaped building, but you can separate them into the 6 component parts.
And it's just by Hanger Lane, is that right?
Yes.
Yeah.
And we're only now concerned with Cresta Court E, which essentially is the middle block of the Cresta Court development. You see from paragraph 2 that 6 separate claim notices, all dated 21st of January, were given to my client, the respondent, stating that the RTM companies intended to acquire the management of the relevant parts of their property. On the 7th of June, unsurprisingly, the properties which they claimed married up with the properties for which they were RTM companies, looking at the second table. We gave a counter notice, paragraph 3, on the 24th of February, taking a variety of different points depending upon which of the buildings we were dealing with. The point to note, and I'll make this act good when I take you through the act in a moment, is that once we gave the counter notice, the RTM couldn't proceed without either us withdrawing it or a determination of the tribunal. And that's the second half of paragraph 3, where the FTT explained why there was an application to the tribunal, and what the tribunal has to decide is whether on the relevant date, which means the date that the claim notice is given, they were entitled to acquire the right to manage. As you see from paragraph 4, we had a series of arguments, different arguments for different buildings. The one we're concerned with today is over the page at 107, the middle bullet point under 7 to 26 Cresta Court. Everything else has fallen away, either because the Upper Tribunal refused permission for it or it's not being pursued. So that's the argument that the relevant RTM company had failed to serve a notice inviting participation on all qualifying tenants. The tribunal recites the argument made in various places. It's a slightly confused recitation of the argument, and what I'd do is just jump to what they decided, because that was rather clearer, which is paragraph 31. The applicant, which below was the RTM company, of course, because they have to apply to determine that they have the right to manage. Their main argument was that the tenant of flat 17 was not a qualifying tenant because her lease was not registered. And then paragraph 32, the FTT finds, well, that doesn't matter because a lease for the purpose of this legislation includes an agreement for a lease. Leases which have been completed but not registered take effect as agreements for leases or equitable leases, and therefore an equitable tenant can be a qualifying tenant. And that, of course, is the respondent's notice argument. They then move on to ask themselves, well, what's the consequence of that finding? They note in paragraph 34 that there was a decision of the Upper Tribunal called Canary Gateway, which addressed this. My Lord Lord, you might remember, Canary Gateway actually ended up in this court, but on a different point. It ended up on shared ownership leases.
And that was after they'd gone round again.
Exactly. So what had happened in Canary Gateway? Mr. Justice Fancourt dealt with round 1. I won that for reasons that were not all the reasons I advanced. Canary Gateway round 2 was then effectively fast-tracked through. The FTT and Upper Tribunal just applied the previous decisions, and we came effectively at first instance to this court. But that part of Canary Gateway hasn't been challenged. It was binding on the FTT in any event. They noted that Mr. Justice Fancourt, who was the then president of the Upper Tribunal, had addressed a scenario where a qualifying tenant didn't receive a notice inviting participation. He concluded, contrary to an earlier decision, that that did invalidate a claim notice. But then, and I'm on 115 now, in paragraph 34, where their judgment starts, however, essentially the point the FTT made there is that the reason the Upper Tribunal found it invalidated is that it's quite easy to work out who qualifying tenants are, and therefore effectively the consequence of that failure should sit with RTM companies. The FTT then at paragraph 35 says, well, that doesn't apply to us here, because it wasn't necessarily that easy to work out who the qualifying tenants were. Because she was unregistered, where would you go to look for it? And so they distinguish Mr. Justice Fancourt's decision on that basis. At paragraph 37, they don't accept that a failure by the RTM company to give a notice inviting participation to a tenant whose leave is not registered will invalidate the claim notice if you have no actual knowledge of the lease. And the only way you could have done it is by following up what was quite a vague note on the freehold title, which simply said that applications are pending. So they found against my learned friend on the respondent's notice point before you, and against me on the appeal. And surprisingly, both sides appealed. And Judge Cooke gave the decision starting at page 58 of the core bundle. And Judge Cooke in paragraph 1 at page 60 states the two issues she had to decide, which are, of course, the same two issues before you. She reversed the order slightly. One of the reasons for that is that the consequences issue had been argued in the Supreme Court in A1, but not yet decided by the time of her judgment. So she focused on the qualifying lease point in oral argument because there was no pending decision that would affect her analysis. And then, as you have seen, she invited written submissions once A1 had been handed down. In terms of points to take from her judgment, I just commend paragraphs 17 to 20 for you. We don't need to go through in any huge detail now, but she's helpfully distilled the facts in slightly more detail than the FTT did, because, of course, she only had the one to focus on, so she could really drill down into their facts. So when you're looking for the key dates for your judgment, I suggest you take them from paragraphs 17 to 20 of here, rather than try and hunt around in the FTT decision to find them all. And then after dealing with the arguments of the parties and decision of the FTT, she turns at paragraph 51 to her decision on the equitable tenancy point. So the factual position here is that there has been a lease granted of this flat. It is not registered, and no notice of invitation to participate was served upon the tenant. Did you need to, is her first question. And she starts at paragraph 53, correctly in my submission, by going first into what the Act says. A person is a qualifying tenant of a flat if he's a tenant under a long lease. She rejects my learned friend's submission that that's a reference to a legal, not equitable lease. She says there's no basis for that in the wording. Leases can be legal or equitable. A long leaseholder is, in terms of ordinary language, the lessee of their flat, whether or not it's registered. A person who has purchased the long lease is the owner. She notes at paragraph 55 that whilst there may well be other statutes, and my learned friend will take you to these, such as the 1967 Act, which deal with express references to equitable leases, she says, well, that's not the way you approach this. You look at this Act. She goes to section 112, subsection 2. She notes that includes agreements for a lease or tenancy. She notes that agreements for leases are equitable leases. She therefore finds support for the idea that equitable leases are included within the definition of long lease from that. She expresses concern that a divide to effectively imply in a legal lease-only limit opens up this risk of this section being incomprehensible to all but the most specialist of property lawyers. And most importantly, her last point, it's impossible to understand why there would be such a distinction. If leases include agreements for leases, then a fortiori they must include equitable leases. She then grapples with, well, what happens if you have a legal lease and an equitable lease, which will be the position, of course, on anything after the first grant. So the vast majority of sales of flats in this country. And she deals with that at paragraph 59. Where you have both a legal and an equitable lease, then it's the legal leaseholder who matters. So that then begs the question, well, what happens if you only have an equitable lease? And that's her paragraph 63. And she says, well, there's only two choices then. If the only interest is the equitable lease, then there's only two conclusions. Either the equitable lessee is the qualifying tenant, or there is no qualifying tenant. Is there a reason, she asks herself, why it would exclude equitable leases? And then she takes you through the reasons that we say are all compelling. The first is at paragraph 64. It's true, as she notes, that equitable leases won't be visible on the land registry. But she says, well, that can't be the answer, because there are other forms of long leases described in the statute as qualifying tenancies, which will not be discoverable on the land registry. I'll take you to those in a moment when I do the scheme of the Act. But the Act already envisages there being qualifying tenants under leases that you can't discover on the land registry. So her holding, and I suggest rightly, is that, well, then there's no great violence to the scheme of the Act to simply include another category of those. Secondly, paragraph 65, she says there's nothing inconsistent with that conclusion with what's said in A1, where the Supreme Court said that it was ordinarily the case that the legal estate would be readily discoverable. She says ordinarily doesn't mean invariably. The addition of one further category of unregistered lease isn't inconsistent with what the Supreme Court said in A1. And then at paragraph 66, she addresses the scenarios in which this unregistered lease is actually going to arise in practice. And she says, well, I can only think of two. The first is where there's a lease granted out of a registered freehold, which is not yet registered. So that's our situation. The freehold title is registered, and then a first grant of a long lease. The second is what's now a much more unusual case, which is where you grant a legal lease out of unregistered land. In those circumstances, it takes effect at law as a legal lease, but if it's not registered within 2 months, then it takes effect as if it were a contract for the creation of a lease. So effectively, the legal element passes into nothingness and the equitable lease is what's left. She says that might be inconvenient because it's hard to discover, but you can't say the Act doesn't allow that, because that second category of equitable lease is no more undiscoverable than the legal lease was in the first 2 months. And then she concludes at 67, therefore, in one case with an equitable lease and no legal lease, the statute provides the answer. She then addresses whether there's any policy reason why that would be wrong. That's her paragraph 68. And she says no. She rejects, in my submission rightly, my learned friend's argument that this is some mischief that's being created, because she keeps coming back to this point. There are already leases that are long leases held by qualifying tenants, which cannot be found on the land registry. So we're not introducing a lacuna into the Act. And secondly, she says the reality is that they are likely to be readily discoverable in most cases, because they'll either live there, as Miss O'Connor does, or they'll be in touch with the RTM company, as Miss O'Connor was. The counter mischief is a problem that she rightly accepted in my submission from a point that we made. If you have to wait for the legal title to be registered before you have a qualifying tenant of a building, you have a situation where, depending upon the workload of the land registry, people could be waiting years for their rights to be vindicated. And you can take judicial notice, I suggest, of the fact that's quite well known that the land registry currently has an enormous backlog problem. You could have a situation where the building is built, the leases are all sold, but it takes 2 years to get round to registration. Why in those 2 years should people not be able to exercise the rights conferred by this scheme? Now, this does give rise to an irony in this case, an irony Judge Cooke was alive to, an irony I'm sure will put back to me. The landlords here are arguing for a more expansive interpretation of leaseholders' rights, which is not normally, of course, what landlords would do. Whereas by contrast, it's the RTM company arguing for a much more restrictive interpretation of leaseholders' rights. Aside from the amusement of the irony of the position being adopted, it is actually quite an important point. Because one of the things my learned friend is going to say to you, and he's right on the authority of A1, is that when we come to consider this Act, we have to bear in mind what its social purpose was, which was to promote the rights of leaseholders. That means, in my submission, promoting the rights of leaseholders as a class, which is not necessarily the same thing as promoting the rights of the leaseholders in this case. So if you come down, on the equitable tenancy point, if you come down to a position where you think there are 2 plausible readings, and we say you shouldn't, we say Judge Cooke is right, that's what the statute means. But if she's wrong about that, if you come up with 2 plausible readings, then you're looking for the reading that does the most benefit to the category of leaseholders as a whole, and that is an expansive category of including the equitable leaseholders. So for those reasons, Judge Cooke held that there was a requirement to have served the leaseholder of flat 17, Miss O'Connor.
Do we know on the facts of this case whether the lease that was originally granted to Ms. O'Connor was in fact preceded by a contract to grant that lease?
We don't, no.
I mean, if it had been, just suppose,
Yeah.
then on any view, during the period when all she had was the agreement for the lease, that would have fallen square within Section 112(2).
Correct.
And then, if Mr. Jacobs' argument is correct, that would then cease to be the position once the lease was actually granted.
Quite.
And then you'd fall into the registration gap.
And
I mean, I know strange things can happen, but that doesn't strike me as a particularly attractive-looking conclusion to reach in that kind of a case.
no, and I would agree and adopt with all that, and that saves me 15 minutes in due course trying to come to that point. No, I entirely agree. We don't know on the facts of this case. You may have seen, it's a side point and there's no criticism of it here, but actually the factual position with her was quite confused below. You may have seen in the Upper Tribunal's judgment, Mr. Joyner, who sits behind Mr. Jacob, was advocate for the RTM company below. He, between the FTT decision and the Upper Tribunal decision, realised he'd made a mistake about a factual point and very properly wrote to correct the position in the Upper Tribunal. Judge Cooke says none of this matters.
This is the wrinkle point.
Exactly, yes. Judge Cooke says, well, I'm going to do this off the findings that were made. Because she says, well, I'm not sure the state of their knowledge really matters. If she was a qualifying tenant, she's a qualifying tenant. But to pick up on my Lord's point, as is often the way by the time you reach this court, you think of other factual matters that would have been nice to explore, but with 6 of them below at first instance, I'm afraid this wasn't a point that was canvassed.
Yes, and I certainly wasn't intending any criticism. I just wanted to know whether I'd missed that point somewhere.
No. And I certainly didn't take it as any criticism. My experience of this court is that criticism tends to be much more direct rather than opaque in that way. That then takes you to her conclusion at paragraph 70 that Miss O'Connor was the qualifying tenant and therefore was required to be served with a notice inviting participation. We then turn to the issue on the appeal, on what did Judge Cooke hold about the failure to serve her. We can, with no disrespect to Judge Cooke, ignore, in my submission, everything she says up to paragraph 128, because most of what she's doing there is tracing through the development of the case law at Upper Tribunal level, Court of Appeal level, and then analyse, and then starting to introduce the A1 case. It's paragraph 128.
It's a very good summary for those who are perhaps not quite so familiar, however, with all this area of law.
It is an excellent summary. And as I say, if my lord would like me to go through it, I'm happy to. They are.
I'm just saying it is.
It's very clear. It's very helpful. I'm not taking how we got to where we got to. In broad terms, you have an initial round of decisions which are mandatory, directory, substantial compliance. 2 Upper Tribunal cases to that effect. We then have an enfranchisement decision of this court called Natt and Osman that suggests that may not be right. That may be appropriate for public law, but not for private law. For private law, we're asking ourselves much more about what the statute intended. A decision then of this court, and a friend and I acted in that one called the Elim Court case, where Lord Justice Lewison, writing the main judgment, says, well, you also need to look much more at the facts of each individual case. And in Elim Court, there had been a failure to serve a claim notice on an intermediate landlord, but that intermediate landlord's lease didn't actually give them any management functions. It was effectively security for a loan. It was a mortgage, an equity release company who'd secured their money by way of taking a lease. And Lord Justice Lewison said, well, that can't have been intended to lead to invalidity there. It doesn't affect the scheme of the Act. And then we get to A1, where we'll look at A1 in some detail, I'm sure, over the course of today. But in broad terms, the Supreme Court say, go back to Synergy. Firstly, ask yourself, does the Act provide for a consequence? If it does, then that's the end of it. If the Act doesn't provide for a consequence, then you're asking yourselves, what did Parliament intend? And that's considered, firstly, by looking at the scheme as a whole. Secondly, by looking at the particular failing in relation to the section. So where does that procedural or substantive failing apply in the scheme as a whole? And then you look at the individual position. But we come to her paragraph 128, and it's paragraph 69 of the Supreme Court's decision. I rely, as I'm sure you've seen, on everything down to the end of the words that she emboldened. I say, we'll go to the full context of A1 in due course, that when you read the legislation properly, Section 78 requires all qualifying tenants who are not already members of the company to be given a notice inviting participation. And then Section 79(2) identifies a consequence for failure to do so, which is you cannot proceed to give a claim notice. It's a do not pass go provision. The difficulty then is what comes after the clear words. For present purposes, we leave aside the difficult question whether this has the further consequence that if a document purporting to be a claim notice is nonetheless given to another stakeholder, such as a landlord, the landlord could rely upon the failure to give a participation notice to a qualifying tenant in order to object to the validity of the purported transfer of the right to manage which followed, even though the tenant might not in fact have any objection to the scheme. That is, of course, our case. That is that difficult question. And then they look at 2 of the earliest Upper Tribunal decisions. Well, actually, the first one, Sinclair Gardens, was Lands Tribunal before the merger of the tribunal system. A Lands Tribunal case and an Upper Tribunal's case, which had looked at the consequences. And they note that they hadn't really had any argument on that, and they reserved their position on whether they were right. So what to do with paragraph 69? And at paragraph 129, Judge Cooke says, well, there's 3 options. Paragraph 130 is option 1, and this is what I argue for. One option is to stop at the emboldened word, follow Canary Gateway, so as to mean that Section 79(2) specifies the consequences, namely that a claim notice is totally invalid and anyone can assert its invalidity. She says that's untenable in the light of the second and third parts of paragraph 69. The second way forward is to follow what the Upper Tribunal had said originally back in Sinclair Gardens and then the Regent's Court case. And she says, well, I can't do that either, because that requires me to ignore what Section 79(2) says. So is that the end of the road? Paragraph 133. She records my submission that it is. The claim notice is invalid and the respondent must start again. But that gives rise to all the consequences the Supreme Court deplored and said were not Parliament's intention in the context of 79(6), so a different provision. So I'm not prepared to do that. So the third way is to do what Mr. Jacobs suggested. And what Mr. Jacobs' argument comes down to, and the argument that's accepted, is that it's not open to a landlord to pray in aid the Section 79(2) consequence. It's only open to a tenant to do so. And the way the tenant would do so is in paragraph 139. She can go to, the tenant can go to court for a declaration that the notice is invalid. It would probably have to be the High Court. County Court doesn't have any inherent jurisdiction here. Alternatively, if she's in communication with the landlord and a counter notice has been served, she can join the proceedings so that she can raise the problem. Or she can seek judicial review of the FTT's decision in the RTM company's favour. But unless she does one of those three things, no one else can take advantage of the procedural failure. And then she expands on that at paragraph 41. Well, 141, sorry. She regards that as consistent with paragraph 69 of the A1 case. It means that although no valid claim notice can be served, if it is served in spite of the requirements, it's not necessarily invalid. It's merely voidable at the suit of the person who should have received the notice and did not. And let me just say immediately that that is what we take issue with. We say if Parliament has specified a consequence, then it is the court's task, the tribunal's task, and all of our tasks simply to give effect to that consequence. What Judge Cooke is doing in that paragraph, or in those paragraphs, and what my learned friend is inviting you to do, is to almost undertake the synergy analysis at the wrong stage. That analysis of void and voidable and only can be taken by the person affected, that's how the Supreme Court decide the A1 properties case. But they're deciding that because synergy is engaged. You can't take what the Supreme Court said in A1 and apply it to a statute where Parliament has specified a consequence. This void-voidable analysis is only applicable because Parliament hasn't specified the consequence, and so the court has to work through what the position would be.
And this takes us back to really fundamental points about statutory construction,
Correct.
doesn't it?
Yes.
I mean, the need to look, obviously, at the language used, and if it provides a clear meaning, which is not objectively so absurd that it can't have been introduced by Parliament, and if it doesn't produce an otherwise sort of unacceptable result, then it's the duty of the courts to give effect to Parliament's language.
I entirely agree.
Whether that produces a result that you might subjectively think crazy or ill-advised or not.
I entirely agree. Parliament is the body that gets to make that pre-synergy choice. It gets to decide if it wants to specify a consequence, and if it does, we just have to all live with it. If it makes that choice, and if it specifies that consequence, our only role is to apply it.
Because we're not legislators.
Quite. And that we can put it narrowly, questions of statutory interpretation, traditional approach to that. We can put it broadly if we wanted to, go into broader debates about the nature of parliamentary sovereignty and supremacy. But it comes back to the same point. If Parliament has made a choice, then subject, as my Lord rightly says, to the usual canons of construction. It could be an Ineos-style error, for example, the presumption against the absurdity. But leaving all that to one side, if Parliament has made a choice, then that choice must be respected. And so when the Supreme Court is talking about the difficult question, what it means by that in my submission, and I'm jumping around into my submissions now, but it's a good place to address it. What it means by that difficult question is that the conclusion that Parliament has clearly reached, which they described in the first part of paragraph 69, does not seem consistent with the rest of the Act. That's why it's difficult. Because as their lordships understand the Act, Parliament shouldn't have made that choice. But nonetheless it did. With all that by way of introduction for the facts and beginning to outline the argument, can I turn to the statute? Because, as my Lord rightly said, this is a statutory interpretation question first of all. So let us go through the scheme of the Act. It's sitting behind tab 1 of the authorities bundle. And we start, if I may, at section 71, which is page 4 of the authorities bundle. And what this explains is that the right to manage is a right which is exercised in respect of premises to which this chapter applied. It's exercised by a company in accordance with this chapter. And it's this chapter which deals how one acquires and exercises those rights. Subsections 1 and 2 should take it all from that. So this isn't one of those statutes like, say, the Protection from Eviction Act, where you've got a load of common law rules on notices to quit, and then statute imposes some structure over the top. This is a purely statutory scheme. Everything you need to understand what qualifies and how you qualify is in here. We then come to section 72, which creates two qualification gateways for two different kinds of premises. And the two gateways are the ones identified in section 72(1)(a). You either have to have a self-contained building or a self-contained part of a building. You can ignore the words with or without a pertinent property for this moment. The Supreme Court have pushed those to one side in the Settlers Court case. So those are your two physical qualifications: self-contained building or self-contained part of a building. A self-contained building is in 72(2). It's a structurally detached building. And a self-contained part of a building is dealt with in section 72(3) and 4. And you're a self-contained part if you're a vertical division, if the structure of your part is such that you could be redeveloped independently of the rest. And subsection 4, your service media is already independent or could be made independent without significant interruption. So at the risk of gross oversimplification, the self-contained building is a block of flats, not touching anything else, no structural attachment. The self-contained part of the building is the row of terraces that have been turned into flats, because the actual terrace house will be attached on each side. Now, there are innumerable minor variations of that. At least 3 of the 4 counsel in this case are going to be back in front of this court in a few months' time arguing about different variations of that. But broadly, those are your two physical gateways. Regardless of which gateway you're using, you still have to comply with 72(b) and (c), which is you have to contain 2 or more flats held by qualifying tenants. So a leasehold house is always out of scope. And the total number of flats held by qualifying tenants has to be not less than 2/3 of the total number of flats in the premises. So if you had a situation where the landlord had built a block of 10 flats and was letting 9 of them on rack rent tenancies and 1 on a long lease, it wouldn't qualify. Now, what section 72 tells us, which is important for this test, important for this case, is that the definition of qualifying tenant goes to the qualification condition for the right. We're all looking at it in this case in the context of who gets a notice, but it's much broader than that. You need to know who the qualifying tenants are to know whether your building even qualifies in the first place. Moving on to section 73, this tells us what an RTM company is. A private company limited by guarantee. Its articles of association state that its object, or one of its objects, is to acquire and exercise the right to manage the premises. You're not a right to manage company if you're a common hold association. There are fewer than 20 of those in the country, so we can put those to one side. You're not an RTM company in relation to premises if there's already an RTM company, so you can't RTM against an RTM company. And you cease to be an RTM company if you acquire the freehold through the vehicle of the RTM company. Section 74 tells us who is allowed to be a member of an RTM company. And again, this is important in the context of the appeal. Because 74(1)(a) tells us that qualifying tenants are entitled to be members. So again, we need to know who the QT is because it goes to who's got the right to join. Landlords are also allowed to join RTM companies, but not until after the RTM has been acquired, section 74(1)(b). But for obvious reasons, otherwise they'd be entitled to see its privileged material during the currency of any dispute. Then we get to section 75, one of the, I suspect, key provisions for this appeal. This starts to tell us who the qualifying tenants are. And 75(1) introduces it by saying this is the section that specifies whether there is a qualifying tenant and if so, who it is. Subsection 2 is the general rule. The person is the qualifying tenant of the flat if he's the tenant of the flat under a long lease. And that's what Judge Cooke looked at in her initial decision, and she makes the point there. It doesn't say registered, doesn't say legal, just says tenant under a long lease. And then we get the exclusions in 75(3) and 4. Business tenancies are excluded. And unlawfully granted tenancies are excluded. That's the point of 4, where you've granted it out of another demise and you didn't have permission to do so. Point we'd make again there is that Parliament, having turned its mind to exclusions, hasn't excluded equitable tenancies. Subsection 5 tells us no flat can ever have more than one qualifying tenant. And subsection 6 and 7 tell us how we identify who the qualifying tenant will be when there are numerous people who could fulfil the conditions. 75(6) tells us that where you've got a chain of long leases, it's the most inferior long lease that qualifies. It's the occupational long leaseholder's right. And 75(7) tells us that where we have joint tenants, they are both jointly the qualifying tenant. So having said that a qualifying tenant is the tenant of a flat under a long lease, we then turn to section 76. Which gives us our definitions as to what is a long lease for these purposes. The vast majority of leases to which this Act is going to apply are 76(2)(a) leases. Leases granted for a term of years exceeding 21 years, whether or not terminable during that period. That's your traditional long lease. Again, no requirement to be registered, just granted for a term of 21 years or more. The remainder are less common. 76(2)(b), leases granted with obligations for perpetual renewal. 76(2)(c), leases for life, although that's perhaps slightly more common than people might expect. and that's because of a decision of the Supreme Court called Mexfield and Beresford, which found that a tenancy that was void for being for an uncertain term actually took effect as a tenancy for life. So there may well be more tenancies for life than one expects. D, leases granted under the right to buy. E, shared ownership leases where the tenant has staircased to 100%. And F, leases granted under the right to acquire, which is the housing association equivalent of the right to buy. Nothing like as common because the discounts are nothing like as generous. You then have further provision about long leases in section 77. I'm not sure any of this will help us with the appeal, but for completeness. 77.1 deals with when things are not to be treated as tenancies for life, essentially to do with some termination provisions that might apply. 77.2 deals with where your long lease has come to an end and a subsequent tenancy has been granted. That tenancy is a long lease irrespective of its terms. 77.3 leases for less than 21 years with provision for renewal but not at a premium, and where the renewal has taken you past 21 years. So you were what happened there is you were granted original lease for less than 21 years, but you paid an enormous premium in knowledge that it would be renewed in subsequent years. 77.4 is dealing with situations where the long lease has expired and you hold over at the end of the term. And 77.5 is where you've got multiple leases of the same property, not in a hierarchy of title, but at the same level, and then they're all treated as one. The only point we make from that is that, again, nothing in here requires there to be any registration. We've got two very detailed sections, 76 and 77. Nothing suggests to you that there's any requirement about registration. Jumping out of order slightly, having looked at 76 and 77, we should now jump to section 112, which is at page 70 of the bundle. And it's section 112 sub 2. In this chapter, lease and tenancy have the same meaning, and both expressions include, so this is not an exclusive definition, where the context permits, a sublease or subtenancy, and this is the important one for us, an agreement for a lease or tenancy, or an agreement for a sublease or tenancy. Judge Cooke takes 2 points from this that we say she's right to take. The first is, if you include an agreement for a lease, which is an equitable lease, why are other kinds of lease not included? And secondly, it's the where the context permits part. That's how she explains that where you've got a legal title and an equitable title, it's the legal title who wins out. So there is a degree of flexibility in how you apply this definition, because the context is the critical bit. But those are the 2 points she takes from it, and we say she's right to do so. Going back into the substantive provisions of the Act, at page 17 of the authorities bundle, we start to get into the procedure by which you acquire the right to manage. So we've looked at what buildings qualify, we've looked at who is a qualifying tenant. This is how you exercise your right. And 78.1 is the important one for this appeal. Before making a claim to acquire the right to manage any premises, an RTM company must give notice to each person who, at the time of the notice, is given, is the qualifying tenant of a flat contained in the premises, but neither is nor has agreed to become a member of the RTM company. So all qualifying tenants have the opportunity to be involved at the outset. Because what the notice inviting participation does, if you see section 78.2, 2C in particular, upon receipt of it, it has to invite you to become a member of the company. 78.3 and 4, 78.3, sorry, and just 78.3. That's the one that makes provision for regulations which have been made about a particular form of notice. I don't think we need to trouble anyone with that. 78.4 provides that the notice of invitation has to be accompanied by a copy of the articles or include details of where you can inspect them. And then there's a saving provision in 78.7. A notice of invitation to participate is not invalidated by any inaccuracy in any of the particulars required by or by virtue of this section. Again, I'm not sure it will matter for this appeal, but in broad terms, the Upper Tribunal case law draws a distinction between an inaccuracy, which can be saved, and an omission, which can't. So if you just don't include something, that is not an inaccuracy. But if you make a mistake, that may be capable of being saved. So that's your notice inviting participation. And that goes from the RTM company to every qualifying tenant who is not already a member of the company. Before we leave 78, can I just draw particular attention to the opening words of 78.1 before making a claim to acquire the right to manage? So it tells us both when this has to be done, which is before the claim, and in my submission that this is the necessary precursor to a valid claim. And that is supported in my submission by section 79 that comes next. 79.1 just creates the concept of the relevant date, because you judge any dispute about RTM by reference to a relevant date, and it tells you the relevant date is the date when the claim notice is given. 79.2 is the critical one for this appeal. The claim notice may not be given unless each person required to be given a notice of invitation to participate has been given such a notice at least 14 days before. And I say two things. They may end up being two halves of the same point. Firstly, that is a consequence. That tells you what happens if you have not given the NIP. Your claim notice may not be given. And secondly, that is not surprising because 78.1 told you the same thing, which is you have to give the NIP before moving to the claim notice. Now, if that's right as a matter of construction, the issue then simply becomes, is there any scope for synergy? And the answer is no. If Parliament has provided a sanction, then that's the end of it. Staying in 79, just to draw out a few more points that I suspect you're going to want to have a look at for the appeal. 79.4 and 5 are important because 79.4 and 5 are further examples of where you need to know who the qualifying tenants are and how many they are, because you have to have a requisite qualifying majority of them in your company to proceed to the claim. So if you've only got 2 qualifying tenants, the obvious example is the maisonette, they've both got to be in. But in any other case, it's not less than 1/2 of the total number of flats. So the so knowing who is the QT isn't just important for who gets the NIP, it's for knowing whether the building qualifies, section 72, and for whether you can even move to the claim notice stage. I also draw attention to 79.8, another right held by qualifying tenants. They're entitled to be given a copy of the claim notice. It is only a copy, but they are still entitled to be given it. So again, we need to know who they are because that's a right that goes with their status. A few other procedural provisions. Section 80, over the page, Parliament has made provision for the content of the claim notice. 80 sub 3 is important because you have to identify each qualifying tenant who is a member of the RTM company in the claim notice. And over the page at 81.1, claim notices have the same saving provision that applied to the notice inviting participation. And inaccuracy is not to doom it, although perhaps a complete omission will.
So sorry, where is that?
81 sub 1 on 23.
Sorry, yes, thank
No, sorry.
Yes. Yep.
Whereas for NIPs, Parliament put that exact provision at the end of the NIP section. They've now put it in a different one for claim notices. It's just the point that it's the same saving provision.
Yeah, thank you.
I am coming to the end of the Act, I hope. Section 84 on page 29. This is the counter notice. So a person given a claim notice under section 79.6, landlord is the obvious category. Sorry, so page 29, section 84.1. A person given a claim notice under section 79.6, that's it, landlord is the most common category of that, can give a counter notice no later than the date specified in the claim notice. The counter notice 84.2 should do one of two things. It should either admit the claim or deny it. If it's denied, 84.3, then the RTM company has to apply to the appropriate tribunal, in England the First Tier Tribunal, in Wales the Leasehold Valuation Tribunal, for a determination that it was on the relevant date entitled to acquire the right to manage. 84.4, they must make that application not later than the period of 2 months, beginning with the day on which the counter notice was given. And 84.5, the effect of giving the counter notice is that they don't acquire the right to manage unless, on an application under subsection 3, they win, or the counter notice is withdrawn. Two final sections. Section 86, just draw your attention to what happens where a claim notice is withdrawn. I just draw your attention to 86D. Qualifying tenants are entitled to be given a notice of the withdrawal notice. So they get a copy of the claim notice so they know the claim has been made. And then if it comes to an end because of withdrawal, they're entitled to be told that as well. And then finally, for the last bit of context, though probably not critical to the appeal, if you get through all of this and you win your RTM, what do you get? The answer to that is section 96 on page 44. What you get, 96.2, are the management functions of the landlord under the lease. And the management functions are defined in section 96.5 as functions with respect to services, repairs, maintenance, improvements, insurance and management. That is, the 96.5 is the first half of the statutory definition of a service charge in section 18 of the Landlord and Tenant Act 1985. So the simplest way to think about it is they're going to get the service charge functions. That's not all they get. They get a right of exclusivity in section 97.2. Anything that they're entitled to do by virtue of this act, nobody else can do. otherwise than with their consent. And then they get certain functions in relation to approvals, because obviously long leases often require you to get consent before subletting, making alterations, etc. And that's sections 98 and 99. (98.2), the consent function under the lease passes to the RTM company. But 98.4, they can't give that consent without having given 30 days or 14 days notice, depending upon what kind of covenant it is, to the landlord under the lease. And then section 99.1 on page 50. If the landlord objects having been given that notice, then the RTM company can't proceed to give the consent unless the landlord withdraws it or the First Tier Tribunal determines they should be able to. Now, I mean, we could spend more time looking at more aspects of RTM. There are certain statutes that are modified where they take over, etc. But for the purposes of the appeal, that seems to me to be the key provisions we need to grapple with. So then I turn to the appeal itself. And we put this as ground one. As my lord's already noted, it bears an awful lot of resemblance to ground three as well. It's a question of statutory construction. Is there an express statement of the consequence of not serving a notice inviting participation on all qualifying tenants? Because if there is an express statement, our task is simply to give effect to it. And we say, yes, that express statement is found in section 79.2. A claim notice may not be given unless each person required to be given a notice of invitation to participate has been given such a notice at least 14 days before. We say A, that's the plain reading of that section. May not be given. Not may be given, but may be voidable in some circumstances. May not be given. And that is consistent with section 78.1, which introduced the notice inviting participation before making a claim to acquire the right to manage. An RTM company must give notice to each person who ... was the qualifying tenant. And if that's right, we say that's the end of the case. Because if Parliament has specified a consequence, frankly, whether anyone in this room thinks it was a good idea, a bad idea, an indifferent idea, makes no difference. That's the consequence Parliament has specified. The reason Judge Cooke didn't accept that is because of what their lordship said in the A1 properties case. And now we need to go to A1, if we can, which is behind tab 10 of the authorities bundle. And can I just start on page 157 of the bundle, page 604 of the report. B down to C, because the law reporters very helpfully tell us what we actually had permission to argue about in A1. And there were two issues. Whether this court's decision in Elim Court was correct on its conclusion that a failure to serve an intermediate landlord with no management functions did not invalidate the claim to acquire the right to manage. And B, and this is the important point, this is the one of broader importance, how should the court ascertain the consequences of non-compliance with a statutory procedure where those consequences were not expressed in the statute?
Yeah, I've lost you. Where are you reading?
Sorry, I'm between B and C now.
Oh, I see, yes. I'm looking at the wrong page, which
No.
will account for my problem. Yeah.
Just framing what the Supreme Court was seized of.
Yes.
Because one of the things that seems to me my learned friend is going to have to submit is that they were actually reinterpreting the whole of the statutory scheme. And they weren't. They were dealing with that second issue was the one of general principle. What do you do in the situation where Parliament has expressed a command in imperative terms but not told you what the answer is if it's not complied with? And my short answer is, that's not our case. They've told us the answer, so nothing in A1 takes us any further at all.
You're saying that we're just interpreting, or applying actually the second limit of Selegie, where the matter isn't
Quite.
spelt out.
Quite, exactly. The point of general application for the textbook writers in due course is that A1 properties is a reminder to go back to Selegie. It's not, whilst the outcomes in cases like Nat and Elim may be right, the divide that was growing between public and private law is wrong, the focus too much on the individual facts is wrong. It's Selegie. It's always been Selegie.
And the sort of the distinctions what we all grew up with many decades ago about the distinction between mandatory and directory, that also has been thrown out of the window, as I understand it.
Very, very much so.
Yeah.
I'm not quite so young that I don't also remember the mandatory and directory distinctions. Yes. And my lord has that. You can go that. Just take that from the head note. Go back to 154. At F, held dismissing the appeal, that where there was no express statement of the consequences of a failure to comply with the statutory procedural requirement. So they're not grappling with what happens where Parliament has specified it. And you can take that even more clearly from 68 at 175. In our view, the correct approach in a case where there is no express statement of the consequences of non-compliance is to ... go into the Selegie analysis. So if there is an express statement, this case, neither this case nor Selegie have nothing to say about it. So why is section 79.2 not an express statement? And I say there isn't an answer to that. It is. It's clearly expressed in those terms. It fits with section 78.1. And their lordships clearly read it the same way. If we look at 68 on 175, the second sentence of 68 starting here, the provisions. So they make the point that sections 78 and 79 are this interlinked two-stage process. I completely agree. Because section 78.1 tells you you've got to comply with it before you move to section 79, and section 79.2 tells you that if you don't get to that stage. And then the first bit of paragraph 69 is in my submission completely correct. Section 78 requires the RTM company, as promoter of the scheme, to give a participation notice to all qualifying tenants who have not agreed already to become, or have not actually become, members of the RTM company. 79.2 provides that until 14 days after that has been done, a claim notice may not be served at all. There will ordinarily be no difficulty in finding or identifying qualifying tenants. The absence of any saving provisions of the type found in 79.7 suggests this is well understood by Parliament. And then this is the answer to my submission to this case. 79.2 imposes a clear consequence of failure in good time to give participation notices. No valid claim notice can be given to anyone. And that, in my submission, is the end of the case. But let me address that difficult question they come on to next. Respectfully, I'm not sure it was a difficult question, because it certainly wasn't a question in the appeal. The question in the appeal was simply, how do you ascertain the consequences of non-compliance? where the consequences are not expressed in the statute.
They refer here to Sinclair and Regent Court, which are the decisions that would be against you. They don't expressly mention the decisions that you might have wished to endorse. Were those also cited?
They were. So go to 156.
So there's Canary Gateway.
There's Canary Gateway. And 155, Triple Rose and Mill House, is referred to. What, as best as anyone can tell, from my friend and I's recollection, and Ms. Gibson, who's watched it all on the Supreme Court website, this appears to have been something the intervener is the only one who commented on during their submissions. Certainly, I don't think either my learned friend or I remember ourselves making arguments about this. It appears to have been a hair that Mr. Rainey set running. No doubt charmingly and authoritatively, but perhaps unhelpfully.
And there were oral submissions from the interview.
There were, yes.
Yep.
But I just want to... So I'd say it's not a difficult question. It's not a difficult question because they know what the answer is. They've identified the consequence and it has to be applied. The reason they think it's difficult is because they struggle to see how Parliament came to that conclusion in light of what they read the legislation as being. But with respect to their lordships, that's neither here nor there. If Parliament has specified the consequences, it's not for any of us to second guess them.
And the theory there would be, well, look, the obligations to notify qualifying tenants and so on must really be designed to protect the interests of qualifying tenants.
Yes, I think it will be.
And if that's right, well, why should landlords be able to complain?
And that's Judge Cooke's point, and that's my learned friend's argument, to which the answer is, it's a short answer, I don't shy away from it. Look at the words.
I wrote a judgment not long ago in which I said something like, the fact that an answer to a question may seem to be straightforward and obvious doesn't necessarily show it's the wrong answer.
Quite. I don't, for obvious reasons, I don't accept that's wrong. I actually say landlords benefit from there being NIP served on everyone as well. But even if we're against me on that, even if this is, yes, another example of landlords taking technical points in order to preserve their interest in the building, so what? If Parliament has said that that's the consequence of it, that is the consequence.
I mean, just going off on a tangent for a moment, it's a bit odd in a sense. As you say, the obligation to notify qualifying tenants is presumably there to protect qualifying tenants. And you're then told, well, you can't issue a claim form unless you've done that. And yet it turns out that even the qualifying tenant can't complain about that in the FTT. You have to go to the High Court,
yes,
or ask for judicial review.
Yes. And that's,
there's a sort of mismatch somewhere.
Very much so, and this is because of the way the scheme is set up. Because it's purely a creature of statute, the FTT's jurisdiction is that defined by Parliament. Section 84(3) is the extent of the FTT's jurisdiction. It only has jurisdiction if an RTM company applies having received a counter notice, and qualifying tenants aren't among the categories of person who can give a counter notice. So you are in this odd position, as you rightly say, that a leaseholder who may be vehemently opposed to this is either forced to go to the High Court to get a declaration or to judicially review the First Tier Tribunal. None of this is very sensible, but nonetheless this appears to be what Parliament has done. Were we sitting as a body considering legislative amendments, I dare say a different scheme would be chosen, but that's not our role. It's simply to give effect to the words. Aside from things like the absurdity principle, it is not for us to second guess why Parliament made that choice.
Do you, perhaps you were going to come to this, but do you get any assistance, seems to me at the moment you do, but reinforcing what you've said, from the very end of the judgment, paragraph 104, and indeed 103 just before it. In 104, the court says the same analysis applies.
Yes.
These are simply examples of provisions where Parliament has stated in terms what the outcome of the failure of compliance with certain of the procedural rules should be, thereby making it unnecessary and inappropriate to conduct a sine die analysis.
Quite.
I mean, it could hardly be clearer than that.
Quite. I was hoping to end on that as a...
Sorry, I was
I like to save my most powerful point for the end, but...
Just revealing my ignorance, I've known of this case for a long time. I've always thought of it as sonergy, but everybody else knows it's sonergy, do they? Correctly.
Oh, is this the decisa problem here in the Brexit case? I've always been taught it was sonergy.
So if that's the general view, I dare say you're all right.
Well, it's the view my then head of chambers, Mr. Arden, beat into me. So it's the view I shall maintain.
Yeah.
Just coming back to 69, but I agree with my lord, yes, and I'll take that point very briefly at the end. I want to deal with what I say is the third part of 69. So the first part of 69 is the bit I say is right, ending no valid claim notice can be given to anyone. The second part is the difficult question, which I say just wasn't before them, and frankly isn't a difficult question in legal terms. It may be a difficult question in parliamentary policy terms, but that's for Parliament to address if they want to. But then I do just need to deal with those two cases they cite, Sinclair Gardens and Avon and Regent Court. Now, obviously, they're not binding on this court or on the Supreme Court. But if we just look at them, we can see two things. The first is that almost none of their reasoning could survive. A1. And secondly, the Upper Tribunal had already moved away from those decisions. So what the Supreme Court have done in the last part of 69 is tell us what the Upper Tribunal used to think without engaging what the current state of the jurisprudence in the Upper Tribunal is. And that's another reason why second and third parts of paragraph 69, they're not ratio, they're not binding, they are an unfortunate slip. So can I just do Sinclair Gardens, Regent Court, and then the three cases where the Upper Tribunal has effectively confined them to their own facts. Sinclair Gardens is at tab 25. This is one of the first cases under this scheme, a decision of the then President of the Lands Tribunal. And just taking it from the head note, just below the first hole punch, the law reporter sets out sections 78.1 and 79.2. And then we get to the facts. The claim notice was in respect of a property which had 3 flats, all of which were let on long leases. It was served by the RTM company on the landlord. The landlord served a counter notice. 2 of the tenants of the flats were members of the RTM company. The tenants of the third flats were a Mr. Mallon and a Miss O'Connell. Miss O'Connell had applied for membership, but Mr. Mallon hadn't. And so the argument is that the failure to serve Mr. Mellon, should have been received a NIP, even though his joint tenant had received one and was a member of the company. And the LVT as it was then, and the Lands Tribunal as it was then, they reject all that for the reasons at page 420 and then 41. At 420, paragraph 7, the then President resolves this by reference to the old mandatory directory distinction in Giantheron. And then you see this at paragraph 10. In light of Giantheron, the LVT was entirely correct in approaching the question of the effect of the failure to comply with the requirements in the way that it did. The purpose of requiring the NIP to be served on qualifying tenant is to ensure the interest of the tenant is protected. They're entitled to receive a copy of the claim notice. If the failure to comply with one of those requirements The principal question is whether the qualifying tenant has in practice had such awareness of the procedure as the statute intended him to have. I mean, there's a number of points we could make about that. One is that doesn't grapple with section 79.2. Two, it's whatever the state of the law was at the time, now it's plainly not right to be using the mandatory directory distinction.
Did Mr. Bartlett use that really? I mean, if you go back to the quotation from Lord Wolf in paragraph 7, we see, I don't know, 10 lines or so up. In the majority of cases, it provides limited, if any, assistance to inquire whether the requirement is mandatory or directory.
But then you turn yourself to asking what is the consequence of the failure to comply, and what's just in all the circumstances.
Is that so different?
That's not the more structured approach in Synergy. And that's one of the points the Lordships make in A1 about there may be cases where you get to the same result on the mandatory directory analysis or on the Synergy analysis, but the way you do it is always as a matter of intellectual rigour. Act as a whole, provision that's been breached, facts of the case. The second of the cases that the Supreme Court cited was the Regent's Court case, which is at tab 13. So what had happened here is that a notice of inviting participation is given to a non-member, but not at the flat in the premises concerned, but at the address he's given for correspondence on the land registry. And the argument on behalf of the landlord was that you had to give it at the flat, and that's because if we just jump very quickly back into tab 1, the Act itself, and have a quick look at section 111 on page 67. It's 1115 on page 67. A company which is an RTM company in relation to premises may give notice under this chapter to a person who is the qualifying tenant of a flat in the premises at the flat, unless notified by the qualifying tenant of a different address in England and Wales. And the argument was, well, that may is effectively a must, and therefore you haven't complied with service, and so you haven't served notice inviting participation. That failed. Sir Keith Lindblom, the then president of the Upper Tribunal, just looking in the head note at H9, page 203, rejects that. Section 1115 is a permissive service provision, not a mandatory service provision. The question, approving what Sinclair Gardens, Tribunal must ask itself whether the qualifying tenant has in practice had such awareness of the procedure as the statute intended him to have. And then H11.3 of the holding, the omission was not fatal to the process. There had been substantial compliance, and it didn't justify denying the right to manage. The short answer to that case is this is actually a service case. There's no suggestion he didn't get it at that flat. No one's got any evidence at all what happened to it after it went to that flat. We just know it went to the flat with the address he'd put on the land registry. Now, this one does appear to have been argued on a mandatory directory divide, and I say that because at paragraph 39, I'm recorded as having accepted, at least in part, the provisions of directory, which was very daft of me. But nonetheless, that does appear to be what I did. And so the President rejected that and said, look, the question is substantial compliance. He agreed at paragraph 41 with what his predecessor as President had said in Sinclair Gardens. He noted at the end of 41 that the provisions are framed in terms of notice being given rather than served or actually received. And then at 56, he comes back to what was the will of Parliament. Can Parliament really have intended this to defeat the whole process? He thinks no, and he thinks the LVT was wrong to consider it even a borderline case. He thought this was a straightforward case of no prejudice whatsoever. But that's not the position on the current state of the Upper Tribunal case law. The first case to reconsider all this was the Mill House case, which is at tab 27. Now, what this was about was a notice of inviting participation had been given, but there was an error in that some of the prescribed notes hadn't been included. And the question is, did that invalidate things? And the Deputy President, Mr. Martin Roger, QC as he was then, gives the judgment at paragraph 40. And this is where we first start to see the Upper Tribunal grappling with section 79.2. The critical importance of the notice inviting to participate is apparent from section 79.2, which prevents the service of a claim notice unless each person required to be given a notice of invitation to participate has been given such a notice at least 14 days before. Section 79.2 is an express provision identifying the consequences of a failure to comply with section 78.1. That consequence is a prohibition on the service of a claim notice. Coming on down, he describes it as an essential precondition to any further progress towards the acquisition of the right to manage.
I'm sorry, where are we reading from? I know it's, sorry, I got the tab, I haven't got the paragraph.
Sorry, paragraph 40.
40.
40, yes.
Thank you, yeah.
And the reason this is important is this Martin Roger, Deputy President, is the first of the Upper Tribunal judges to draw attention to 79.2.
Yes, thank you.
And to describe it as an express provision identifying the consequences of a failure to comply. He describes it as an essential precondition to any further progress. And he makes clear that to the extent Sinclair Gardens says something less than full compliance might be good enough, this ought not to be relied upon. Now, in my submission, that's still good law as a conceptual approach. If there's a consequence, you don't get to Synedgen. It just brings you back to the question of, is it a consequence? The Upper Tribunal returned to that theme in the unappealed aspect of the Canary Gateway case, which is behind tab 14. What had happened in this one, it was an intermediate lease held by a housing association of a number of flats. In some of the flats, they'd sublet them on shared ownership leases, and on some of them, they'd retained them and let them as weekly rental tenancies. So the question was, were they a qualifying tenant of the weekly rental tenancies? And the answer is yes, because there was no inferior long lease. They hadn't received a notice inviting participation in respect of those weekly rental tenancies. So what was the effect of that? And Mr. Justice Fancourt grappled with that at paragraph 82. Section 78 states that a notice of invitation to participate must be given to each person who is a qualifying tenant and prescribes certain form and content for a notice. As with the apparently obligatory requirement in section 79 to give a claim notice to each landlord, the mandatory language is not determinative of whether the failure to comply has the consequence of invalidating the claim. I agree with all that. But then carrying on to the last sentence, section 79.2, however, goes further and states that a claim notice may not be given unless each person required to be given a notice of invitation to participate has been given one at least 14 days before a claim notice is given. And then 83. The purpose of 79.2 is not to require a notice of invitation to participate to be given, or specify to whom it must be given or what it must say. That is done by section 78. The purpose of 79.2 is either to specify the consequence of non-compliance with section 78, or to specify the time that must elapse before a claim notice may be given, or both. On the face of it, section 79 does both, but that is an issue of interpretation that requires the context and implications to be taken into account before construing it. And then he reaches his conclusions at 90 and 91. Bearing all these points in mind, it appears to me Parliament did intend failure to give section 78 notices as required to invalidate a claim notice, and 79.2 should not be interpreted as merely a stipulation as to when a claim notice may be served. The natural and ordinary reading of 79.2 is that a purported claim notice that is served otherwise than in accordance with its terms will be invalid. If all that Parliament had meant to do was to require NIPs to be given at least 14 days before a claim notice is served, that could have been achieved by placing the words at least 14 days before the start of 78.1. And then at the end of paragraph 91, he grapples with what we should do about the Avon Freeholds and Regents Court case. And he says at the end of 91, that decision should not be followed as an authority on the right to manage provisions. And then finally, this one wasn't cited to the Supreme Court, and you'll see why when I take you to it, but the final case in the Upper Tribunal's trilogy of rowing back from Sinclair Gardens and Regent's Court is the Baron's Estate case at page 253. And it's paragraphs 25 down to 28. And as you can see, the Upper Tribunal's position is that the issue of to whether or not 79.2 is a consequence that has the effect for which I describe is now settled at Upper Tribunal level. So at paragraph 25, this issue must be regarded as settled at this level by the decision of the Tribunal, Sir Timothy Fancourt President, in Avon Ground Rents and Canary Gateway. Paragraph 26 explains what Avon Ground Rents decided. Now, none of those 5 cases is obviously binding upon you. None of them are binding upon the Supreme Court. My point is a different one. My point is that having introduced the 2 oldest cases, if the Supreme Court were really purporting to decide this issue, they would have gone on to grapple with the 3 more recent cases, the 2 substantively reasoned ones of which we cited to them. Failure to do so, I say, is an indication that you can, with all due respect, but quite safely say, the first part of paragraph 69 is a correct statement of law. It is consistent with the wording of the statute. It is consistent with the current practice of the Upper Tribunal. The second part, the difficult question, did not arise for their lordships, and the difficulty to which they are referring is that they are struggling to understand why Parliament has provided for that consequence. But that's a matter for Parliament on amendment, not a matter for interpretation to make the words mean something else. And then thirdly, the 2 cases to which they were referred, to which they referred in their judgment, were not the current state of the learning. And whilst no one suggests that the 3 subsequent cases were binding upon them, if their lordships really meant to grapple with this difficult issue, they would have grappled with it in the two cases which explain why you shouldn't follow Sinclair Gardens and Regent's Court. The reality is, if you take the last few words of paragraph 69, this was a peripheral part of the debate before us. It was so peripheral as to be inconsequential. What A1 tells us, coming now to the point my lord helpfully took me to some time ago, you come back to the fact that A1 is not changing the substantive law. You don't get to synergy if Parliament has specified a consequence. That's paragraph 104. Parliament has specified a consequence. And whilst the Supreme Court is clearly dubious about that consequence, that, to quote from the end of 105, cannot outweigh the more significant indications as to Parliament's intention. And the more significant indications as to Parliament's intention are the words themselves. I have two other very short points to make, one that falls under ground 2 and one that falls under ground 3. That's purely for presentation purposes. They all feed into the same argument I'm making. The first is, as you saw when I took you through her decision, Judge Cooke clearly felt she couldn't disregard what was in the second and third parts of paragraph 69. Can I just take you to a decision called Harrison, which is at tab 19, an Upper Tribunal case in the tax chamber, but just grappling with how we approach obiter and unargued comments in judgments of superior courts. And I want this simply as it's a helpful recitation of the principles. It was this or trot out Benyon. It's page 323 of the bundle, paragraph 50. My time is being used up, so I won't read it all out. Paragraph 50, but in particular 51 and the indented provisions. And halfway down the indented provisions, starting, a mere passing remark or a statement on the assumption of some matter that's not been argued is one thing. A considered judgment on a point fully argued is another. I think it was Sir James Mumby who put it in one of the cases that there's dicta and there's dicta. Those second and third parts of paragraph 69 are at the less powerful end of dicta. They're not argued. They don't fit with what was actually in the appeal. They don't reflect the current state of the learning. That's why Judge Cooke could, and I say should, have felt free to stop at the end of the first part of paragraph 69. A point under ground 3, slightly anticipatory of something that I'm sure my learned friend is going to say. Both Judge Cooke and my learned friend rely upon what one might term the broader policy of the 2002 Act. And for completeness and possibly with a view to saving him some time in due course, if you just go to page 161 in the authorities bundle, paragraphs 22 to 26, that's probably the most complete statement of the policy of the Act. And broadly, it is to give more power to leaseholders over freeholders. I don't dispute that. I can't dispute that. That clearly is something that was binding. It was being argued about us in this case. But it doesn't help you. Because where that would come into play is if we were doing a synergy analysis. Because in asking ourselves, what did Parliament intend the consequence to be, we have to ask ourselves, why was Parliament legislating? What was it trying to achieve? My submission to you on this case is we don't get to that. Parliament has made its choice, and for whatever reason, good, bad, or indifferent, that choice was made and must be applied. The way it's been put subsequently, if you go to tab 22, the Leyden case, the first Supreme Court decision to consider A1 after it was produced, and this is about a failure to arraign someone within an appropriate period of time. It's a very short quote at paragraph 66 down to 68. It reiterates that we only get to synergy if the consequences of non-compliance are not spilled out. And in any event, 68, synergy itself isn't a wholesale jettisoning of the rules affecting procedure. It's about keeping synergy in its proper place. And its proper place is those cases where Parliament has not specified a consequence. The final point I wanted to make was this on ground 4. If I'm wrong on all of this, and if there is some scope for a synergy type analysis, I did argue before Judge Cooke, and I repeat here, that it's not as simple as saying that the notice inviting participation is exclusively about making sure that the leaseholders know about their right to join the company. That's why I took you through the other rights they have. But more than that, it does benefit the landlord to have as many people served with a notice inviting participation as possible. And that's for two reasons. The first is that if the landlord is going to lose control of their property, common sense tells you they'd like to lose it to a company that is not going to collapse weeks later. Because when the RTM companies fail, everything just reverts back immediately. Having more people in an RTM company is good for landlords. It's more people available to be directors to fulfill the functions of that company. The worst scenario for a landlord is to lose a building to RTM and then the RTM company to just fail quietly. Because under the scheme of the Act, he'll get the management back immediately and maybe inheriting a complete disaster. If you're going to lose it, you want it to work. And the final point I wanted to make, it's a very, very short point, is that there's another benefit to landlords in having more people in RTM companies, which is that there are certain rights for landlords to recover certain costs from RTM companies. The precise cost rules changed in March. It doesn't matter for the purpose of this discussion. But the right to recover from RTM companies extends to a right to recover against the members of those companies. And so having more people in the company gives you more targets for your recovery of funds. Just for your notes, because I don't want to stray over, for your notes, now the rights to recover against members are found in section 87 big A, subsection 5, which is in the authorities bundle at page 37. And then section 87 big B, subsection 3, which is the next section along in the bundle. It used to be found in sections 88 and 89, but there's been a change that's of no consequence to this appeal, moving some of those provisions around. It's not as simple as saying that the only purpose of NIPs is to let leaseholders join the company. But my case is very much we don't get to this. My case is very much Parliament has made its choice. And entirely out of keeping with my normal practice, I've stopped bang on time. Unless I can help you with anything else.
No, I don't detect any more questions, so thank you very much, Mr. Bates. Mr. Jacob.
Yes. Well, one of Mr. Bates's last points near to the end is my starting point. That is within the A1 Properties case, Supreme Court, tab 10, page 162. Supreme Court in paragraph 25 at the top of the page seeks to ascertain the general overall purpose of the right to manage provisions from the consultation paper that preceded it. And there's a quotation there from paragraph 10 of section 3 of the consultation paper indented there, talking about the main objective being to grant long leaseholders of flats the right to take over the management of their building collectively without either having to prove fault on the part of the landlord or to pay any compensation. And then I particularly highlight the next sentence: the procedure should be as simple as possible to reduce the potential for challenge by an obstructive landlord. And in my submission, this is a classic case of an obstructive landlord seeking to use procedural tripwires effectively to trip up a right to manage company and obstruct its acquisition of the right to manage. And that applies really to both issues, the one raised by the appeal and the one raised by the respondent's notice. On the respondent's notice, the landlord seeks to expand the class of qualifying tenants to include equitable tenants because they will be more difficult, if not impossible, to identify, therefore making it more of a tripwire situation for the right to manage company and therefore enabling the landlord to obstruct the acquisition of the right to manage. In relation to the consequences issue, the landlord is now trying to essentially hijack the rights of the qualifying tenant to receive a notice of invitation to participate, to again try to obstruct the rights of the tenants to gain their right to manage. So it's nothing actually of any consequence to the landlord. I mean, there are some points about costs which I'll come to, but in general terms, I say it is a landlord trying to use the rights of others as obstructive to the acquisition of the right to manage. Despite this supposed to be, Parliament intended this would be a simple procedure. And in my submission, if you do find for the right to manage company on either or both of these arguments, it does make it a more simple procedure in line with Parliament's ultimate intention. There may also be some interdependence between the two issues, that if you conclude that equitable lessees come within the class of qualifying tenants who are supposed to be served with NIPs, NIPs, various different ways of describing the notice of invitation to participate. If you find that equitable lessees are included within that, and therefore it is much harder for right to manage companies to identify and serve them, that may lend force to the argument that Parliament could not have intended that there would be this bright line rule that if one is missed out, even if impossible to identify perhaps because of the nature of their lease, that will just draw an end to the procedure and it will have to be restarted. The issues do come out of order in the way that the tribunal below decided them, but starting with the issue raised by the appeal, which effectively should come second, but as it's being dealt with in this way. What is the consequence, assuming that Miss O'Connor was a qualifying tenant who should have received a NIP? What is the consequence of the failure to serve one on her? Well, the statute must be considered in light of the general overall purpose, as I've just highlighted in A1 properties. We have two key sections that are relevant, section 78 and 79. So if I could just go back to those. Tab 1, page 17, we have section 78. So 78.1 is the provision that my own friend showed you, requiring the service of the NIPs on the qualifying tenants unless they have agreed or are in fact already a member of, agreed to become or are already a member of the right to manage company. The purpose of this is clearly to give information to the tenants and to give them the opportunity to participate in the right to manage. It is for their benefit. In my submission, it's for no benefit of the landlord. It is simply for the benefit of the tenant. That's the purpose of this. Now, my learned friend in his skeleton, he submits that there's a broader purpose, perhaps. One point of this is his argument about costs. He says, well, under section 88, now repealed, but it would apply to this case, the landlord can recover costs of receipt of dealing with the claim notice from the company itself, but also section 89.3 obliged all of the members of the company to be liable jointly and severally for those costs. So he says, well, that serves the landlord's interest to increase the pool of people who could pay our costs. Well, in my submission, that's not the purpose of this. That may be a knock-on effect, but the purpose of this provision is clearly for the benefit of the tenants. And the way that the landlord is protected, so far as it should be, for the ability to recover costs from a pool of tenants, is in, sorry, if you just bear with me, section 79, 3 to 5 in my submission. If we just turn to page 19. So, section 79.3 says that the claim notice must be given by a right to manage company which complies with subsection 4 and 5, or 5, sorry. And 4 and 5 give the minimum amount of qualifying tenants that can give the claim notice. So, if there are only 2 qualifying tenants, looking at subsection 794, then both of them must be members. And in any other case, which would normally be the case, it must include a number of qualifying tenants of flats contained in the premises which is not less than 1/2 of the total number of flats so contained. So there's a bare minimum number of qualifying tenants who are required to give the claim notice. In my submission, that is all Parliament has seen sufficient by way of the number of people who should be able to pursue the claim and therefore who should contribute to any landlord's costs. And that's sufficient to deal with the argument that the landlord should be able to recover them from a pool of people. They have a bare minimum which should be sufficient for these purposes in my submission. But in my submission, that's clearly not the point of section 78. It really has nothing to do with whether the landlord has enough people to recover costs from or not. It's about giving information to tenants and enabling them to participate. It's worth bearing in mind that even if they don't receive such a notice, they do still have the ability at any time to join the company, whether before the claim notice is served or after the claim notice or after acquisition. So whilst they may not have an opportunity at a much earlier stage, it doesn't stop them from having a right later to do what this is inviting them to do. Section 79.2, the next key aspect of this, which you've been referred to, is the provision referred to by the Supreme Court in A1 Properties. Now, to highlight the point here that my recollection, we weren't arguing anything really about section 79.2 in the Supreme Court. My learned friend says, perhaps from his junior who has actually viewed the tape recently, that it was Mr. Rainey who mentioned something about this. I don't know what he actually said because I haven't read the tape and I only just found this out now as to where this came from. But neither part of it, my learned friend seems to draw a distinction to say, well, the first part is very clear and essentially you can rely on that. For the second part, well, that wasn't really the argument. For my part, I would say nothing really was decided there. Nothing was argued about this, or it wasn't part of what the Supreme Court was deciding. I support the Upper Tribunal Judge Cooke's analysis in this case, that it's all an obiter element of the decision. We were focused on the question of the consequence of failure to serve a claim notice. Nobody was focusing on this. And to the extent Mr. Rainey mentioned it in passing, that he may have said something which was attractive to their lordships, and they thought it should feature as part of their run-through of the statutory scheme. But it's not crucial to the analysis as to the failure to serve the claim notice in my submission. The real purpose in my submission of 79.2 is actually the timescale which it sets out there of 14 days. What it's trying to do is to give a minimum period for recipients of NIPs to consider their position. They need some amount of time to decide whether to do something to join before the claim notice is given. And it says it may not be given unless each person required to be given a notice of invitation to participate has been given such a notice at least 14 days before. So that's the period of time Parliament thought appropriate for them to consider their position and apply for membership if they wish to do so. And I do note that my learned friend took you to Mr. Justice Fancourt's decision in the Canary Gateway Upper Tribunal case. And in part of that, he said, well, this could have two potential purposes. One could be the time limit, and one could be specifying a consequence, or it could be both. In my submission, actually, the principal purpose of this should be the time limit. That is the key consideration, to give the time to act on the NIP.
And just taking out of your order, suppose that the claim notice is given 7 days after, what do you say the consequence is?
Well, we don't have to deal with that here. The consequence of that would suggest, yes, without having to deal with it, but there would be a clear consequence in my submission that would be inability to give because the 14-day period had not been given.
And so the clear consequence, there's a follow-up question coming. I'll just write down this point.
Although there is a secondary point which I'll come to about what happens if a right to manage company actually still gives one anyway, which, as you say, there's perhaps a nuanced.
And that may be where I'm going with the supplemental point. So suppose there were a purported claim form 7 days in. You say, well, that's illegitimate. You also say, well, this is really for the benefit of the tenants.
Yes, this is, in my submission, this is exclusively for the benefit of tenants. It's not for the benefit of the landlord in any way.
Would it be right, following Judge Cooke's thinking, that the tenant could only take the point by High Court proceedings, including potentially judicial review proceedings?
Yes, that follows from the fact that qualifying tenants are not given a right to serve a counter notice.
Yep.
So Parliament has decided that only landlords and certain other parties referred to by the Supreme Court as stakeholders, but management parties in lease, management companies in leases, and managers appointed by the tribunal. So they all receive the claim notice. You'll see actually on this page 79.6, it has the list of parties who receive the claim notice, or they must be given the claim notice. That's different to the copy that's given to qualifying tenants. I don't know if I mentioned that. So 79.8, page 20. Qualifying tenants get a copy. The landlord and other stakeholders get the actual claim notice. And the ability to serve the counter notice, section 84 you were taken to, that's page 29. 84.1, a person who is given a claim notice by a RTM company under section 79.6 may give a notice referred to as a counter notice.
And you're not going to give the claim form to all the qualifying tenants?
Well, you give a copy to all the qualifying tenants, but they can't actually respond to it because it's not the claim notice, it's just a copy.
So just thinking around it for a moment, suppose that an RTM company didn't give notice to any tenants at all, but nevertheless issued a claim form. That wouldn't be something a landlord could complain about.
Well, in my submission, the failure to give the NITs would not be. There may be lots of other things that might crop up in the scheme the landlord could complain about if nobody's been given these notices. They would still need, well, the company would still have to have sufficient members to...
But it might have sufficient members. I mean, suppose more than half the tenants had become members.
Yes.
And then 45% of the tenants didn't like all this. And the RTM company decided not to give them notice at all, but nevertheless applied. The landlord couldn't complain. You say, well, that's perfectly consistent with the statutory scheme because this is about protecting tenants, not landlords.
Yes.
But the landlord couldn't complain, and a tenant could only complain if they adopted this strange non-FTT procedure.
Yes. Well, that is the nature of the scheme. A tenant has to go to the High Court for a declaration. The tenant has no right to assert themselves
in the FTT.
Yes. But I mean, the flip side of that is that the landlord can override the tenant's rights if they wish to. The landlord can agree to a scheme, although that's almost perhaps theoretical. In your lordship's example is quite theoretical and extreme. There's another extreme where a landlord can agree to a right to manage claim despite opposition from tenants. And the Supreme Court actually, in fact, envisaged a right to manage company buying off a landlord. That's part of their analysis of how deemed acquisition works. Just bear with me, I'll try to remind myself of where that...
I remember reading it, but I can't remember where.
Yes, that's paragraph 80, according to my notes. So if we go to tab 10, on page 178. This is part of an analysis when they go through case A, B and C. They try and distinguish different scenarios to see what the Parliament's intention might be. Paragraph 80, they're dealing with case A, where there are two landlords, but only one is entitled to get the claim notice. The other one is invisible, that it just can't be ascertained who they are, so therefore they don't actually have an entitlement to the notice.
Yeah.
And then they say the first landlord is given a claim notice and does not serve a counter notice because it is content with the scheme or has been bought off by the right to manage company. The second invisible landlord is not given a claim notice and therefore cannot give a counter notice, even though when it later finds out about the scheme it wishes to make a perfectly legitimate objection to its validity. Without entitlement to receive a claim notice, it's plainly not entitled to give a counter notice, and therefore, by virtue of section 93, there is deemed to be no dispute about entitlement and the scheme takes effect on the date specified in the claim notice. So the landlord can ignore any defects in the scheme, potentially. It could ignore the membership requirements, whatever, potentially because it's bought off. It's given some kind of incentive by a right to manage company not to object. The invisible landlord can't object by giving a counter notice in the same way a qualifying tenant couldn't object by giving a counter notice. It seems the remedy that the Supreme Court envisages for anybody who can't actually engage is to go to the High Court. So however inconvenient it might sound or difficult, that is the qualifying tenant's only remedy to protect his or her or its own interests.
And just picking up one more point. Am I right in understanding your case in effect, or Judge Cooke's decision in effect? Well, section 79.2 is a bright line, but it's a bright line that can only be asserted by the people who it was intended to protect.
That's perhaps a reasonable way of explaining it. I mean, the starting point in my submission is that what was served, I say, must actually be a claim notice within the scheme. And then Judge Cooke says, well, it's voidable at the instance of the tenant. But the starting point is it a claim notice? So if the situation is so stark that it simply can't be given, and what is actually sent is not a claim notice within the scheme at all, then the entitlement of the landlord to give the counter notice does not arise. If there is no actual claim notice, they can't respond to a claim notice, there isn't one. There's no counter notice. And the tribunal's jurisdiction doesn't arise either, because that is all dependent on a counter notice. The Supreme Court made the point, paragraph 82, about the FTT being a statutory body and the routes to its jurisdiction are very clearly defined. So this route we've gone down here is claim notice, counter notice, application under section 84.3 to the tribunal because of a counter notice objecting to acquisition. Unless what was served is actually a claim notice within the meaning of this statute, we can't have gone through any of that. There would be no ability to serve a counter notice. In my submission, if one approaches it on that analysis, that it's not actually a claim notice at all, there would actually be deemed acquisition under section 90. Because if some document purporting to be a claim notice is served and there's no response, one can have deemed acquisition even if there are flaws in the scheme. The Supreme Court has been very clear about that. And the remedy would then be to go to the High Court for a declaration that actually the acquisition was invalid. But the way everybody's approached it here, and I say the correct way, is that this is actually a claim notice within the scheme. It does trigger the entitlement to serve a counter notice, and then the trip to the FTT and all the way up to here to clothe the tribunal with jurisdiction to decide this, and this court as well to decide whether the Upper Tribunal is correct in its approach. But given, if I'm right, we have the claim notice, the Upper Tribunal, in my submission, has come up with a sensible way of approaching Parliament's intention to its validity, that it is valid as a claim notice to trigger everything that has followed, but it must have some consequence of not serving it on this one qualifying tenant, assuming she is for present purposes. And the way of dealing with that is to say that it's voidable at her instance. And in my submission, there are various factors I can point to in the statutory scheme which show that Parliament could not have intended a landlord to be able to take this point. It should only be a qualifying tenant who can take the point that they have not been served with the notice that was for their particular interests. So the first element of this is the requirements of a claim notice, I say. I'd like to take you to sections 80, 81 to look at what information must be in a claim notice. So if we go to tab 1, page 21, so this has the key contents of a claim notice. The premises must be specified 80 subsection 2 and the grounds upon which it's claimed they are premises to which the chapter applies. Then 3, subsection 3, we need the full name of each person who's both the qualifying tenant and a member of the company. So we're not dealing with people like Miss O'Connor, who wasn't a member at the time. And then it has various details in relation to those people. So the members need a lot of detail set out as to their identity and the terms of their lease. Then it has to specify a date on which the account notice must be served, 86. A date for acquisition is 87. And then it has other particulars as may be contained in regulations, but in section 88 and 9. There are some regulations I'll come to in a moment. Section 81 on page 23 contains some supplementary provisions relating to claim notices. It doesn't actually deal with what needs to be included. It's some other information. 81.2 deals with somebody whose name is stated on the claim notice but is not actually a member. It doesn't say anything that needs to be added to what we already have in section 80 and the regulations made under section 80. Those regulations, you will find part of them at tab 3. So the right to manage prescribed particulars and forms, England regulations 2010 being the applicable ones for this case. Regulation 4 has additional content of claim notice. What you'll see here is that it's just a number of statements and or pieces of information that are provided mandatory provision to the recipient of the notice. And most of these are just referring to parts of the statute. So Regulation 4A is a statement of the effect of section 92. The next one relates back to section 74. C is section 81. So it's giving information. There's also a form of claim notice, which you can see at Schedule 2 on page 91, which also has some notes attached to it. Now, what I'd ask you to note here is that none of this requires the claim notice to give details of the qualifying tenants upon whom NIPs have been served. None of this requires the date of service of any NIPs to be given to the recipient of the claim notice. Doesn't require them to give a copy of the NIP that was served to the recipient of the claim notice. It doesn't require them to give evidence of service of the NIPs to the recipient of the claim notice. Now, section 82 of the statute enables a right to manage company to obtain information from certain parties to assist in the acquisition process. That's tab 1, page 25. But that right to information is for the right to manage company. There's not a right to information for the landlord who receives a claim notice under the statute to say, under this section, I require you to provide me with a copy of the NIP, evidence of service, and a list of tenants on whom you served it with the address of service of each of them. So the statute is not giving the landlord the information or other stakeholder who receives a claim notice. It's not giving them the information required to make an informed choice as to whether or not there's been compliance with section 78.1 for service of NIPs. So given what the statute requires the recipient of the claim to be given, they could potentially make a speculative opposition in a counter notice on the off chance there's been some non-compliance, or they could admit the right has been acquired in the dark as to whether NIPs have been properly served. But unless the right to manage company volunteers the information, the statute is not requiring them to have the information to enable them to ascertain compliance. And I submit that this supports the argument that Parliament did not intend this to be a point for landlords to take. They're given a whole wealth of information which is very important for them to take proper objections. So a proper objection for a landlord who is not merely an obstructive landlord seeking to rely on procedural tripwires, but actually wants to take a genuine point, a proper point would be, do these premises comply? Are they premises to which this statute applies? Is it a self-contained building? Is it a self-contained part of the building? That information must be contained in the claim notice. The server must say what it is and why it's said to be premises to which the right applies. And so there's a clear distinction we can see in my submission between what Parliament intended the landlord to be looking for, what Parliament intended to be a proper ground of opposition by a landlord, and the other thing, which is what was something for the benefit of the tenants, which should not be used to interfere by an obstructive landlord. The second point following on from this is that a recipient of a claim notice really needs to know their position, to know what to do. There are various recipients that you'll see in section 79.6 on page 19, not just landlords, but other parties to leases who are other than landlord and tenant, so that can apply to management parties, potentially guarantors under leases. There's a whole range of parties who could be served with a claim notice. The claim notice need only give them 1 month to serve a counter notice. Page 21, section 86. Claim notice must specify a date not earlier than 1 month after the relevant date, being the date of giving the claim notice, by which each person who was given the notice under section 796 may respond with a counter notice. So they don't have too much time, the recipients, to try and work out their position. Will they object? If so, on what grounds? Will they admit it? Will they do nothing and let deemed acquisition occur because there were no counter notices? They have a short space of time, and if they don't oppose this, there's a whole range of impacts that occur, and I know friends took you through that. The management functions passing, obviously a key one. There's also another one not mentioned, but section 94.1, which I'm not sure if we have that. There were some sections that got omitted from the bundle by accident. That might be one of them. But I don't necessarily need to take you to it, but we do have copies if you want. But there's a duty to pay uncommitted service charges to the right to manage company.
To pay uncommitted?
Well, to take the exact wording, where the right to manage premises is to be acquired by an RTM company, a person who is, and then it sets out a list of people who receive claim notices, must make to the company a payment equal to the amount of any accrued uncommitted service charges held by him on the acquisition date.
I see.
So they may have sinking fund or reserve fund. They may have some money they have to actually pay over.
Yes.
So there's a lot of important things that arise from this if they fail to oppose. They have little time to decide. They would need to have the information to make an informed decision because of all these important consequences. If Parliament intended the landlord to be able to take this point to use qualifying tenants' rights to their benefit, one would expect Parliament to ensure the recipients of the claim notice had the right information to take the point, to know the point existed and to take it properly. But despite giving them a wealth of information as required by the statute, they don't get this information to make this choice. And that's in my submission because Parliament did not intend them to have that opportunity. And my third point, Parliament did not, in my submission, intend landlords to be the guardian or protector of qualifying tenants' interests. why, I ask rhetorically, why should Parliament intend that the upholding or not, or waiving of a qualifying tenant's right to receive a NIP is in the gift of the landlord? Given by its nature, this scheme usually arises where tenants are unhappy with management and a landlord wishes to obstruct and retain the management. Why should Parliament intend that a landlord could object to a scheme and scupper it, despite the actual tenant involved wanting it to go ahead? The precise situation we have here, Miss O'Connor is currently a member of the Right to Manage Company. She supports the scheme. Her rights are being hijacked by the landlord, I say illegitimately, to try and scupper this scheme. I support the analysis of Judge Cooke at page 138 of her judgment. She deals with this. That's core bundle, page 87. Where she's effectively saying what I've been going through in a different way. Paragraph 138 on page 87, if I could just invite your lordships to read that. So, in my submission, the factors that I've gone through all point to the conclusion that Parliament did not intended for a qualifying tenant affected by this to be one who takes the point if necessary, not for a landlord to take the point. And in my submission, it should be for a qualifying tenant to waive the issue if she wishes to do so. She obviously has no intention of trying to defeat this claim here. There are some paragraphs in the Studio case I'd like to highlight. Now, even though that was dealing with failure to serve a claim notice, there were some...
Sorry, which case are you going to?
Tudor Studios, the Supreme
yes.
Court. So even though it's dealing with failure to serve a claim notice, it's a different point, but there is some commentary there, which I say are general principles of wider significance, which can be adapted and applied here, which is essentially what Judge Cooke has done. So if I could take you to page 180, paragraph 88. So here, their lordships have decided that the appropriate way of dealing with the procedural breach in that case is the voidable situation. So the claim notice is voidable at the instance of the party who didn't receive it. At 88, of course, a consequence that the scheme is only rendered voidable is that the person with the right to seek avoidance can disclaim or otherwise abandon that right. Whereas if it's rendered the scheme void, the subsequent conduct of the relevant landlord or stakeholder would be irrelevant. So I rely on that to say, well, Miss O'Connor, if she was a tenant entitled to receive a notice, she could waive her right to do so. It goes on to say there are numerous indications in this part of the CLARA, the relevant act, that persons with a right to object should be able to waive that right. There is no jurisdiction in the tribunal to revisit and undo a transfer of the right to manage which has purportedly occurred as a result of the operation of Section 90 or a determination of the tribunal. So the way in which a challenge would be brought would be by proceedings in the High Court, seeking a declaration of rights, or seeking judicial review of the order of the tribunal and a declaration in the latter. Since the exercise of the right to avoid is generally subject to equitable considerations, delay or other unconscionable conduct of the relevant landlord or other stakeholder could lead to the right to avoid being lost or refused as a matter of discretion. So, whilst applying to the claim notice and the recipient of the claim notice, in my submission there can be a similar analysis to the recipient of a NIP. Just bear with me a moment. There's further analysis at paragraph 92, which again Judge Cooke has adapted for considering the question here, but it was there dealing with the claim notice. 92, in both cases, the focus is on the position of the party directly affected by the procedural omission. The omission does not give other persons who are not so affected, for example, other landlords who have been properly served with a claim notice, a right to object to the making of a transfer order if the party who is so affected has not sought to complain about this. There is no good reason to suppose that Parliament intended that a person which has not itself been affected by a procedural omission in relation to another should acquire by a windfall a power to thwart the operation of the statutory process, which it would not otherwise have enjoyed. If a party with a potentially valid substantive objection has not been properly served and has been left out of the process, they have the right to apply to the High Court, as explained above. Hence, RTM company cannot simply ignore them with impunity. So in the extreme example of lots of qualifying tenants not being served because the right to manage company believes they're going to object, so it takes a conscious decision to exclude them from the process, very different to our facts, but they can't do that with impunity because those tenants all have this remedy to go to the High Court. And if it were such an extreme case of a 49% who objected and they all went to the High Court, then one could see that perhaps as the easiest example of the High Court declaration being granted to say, well, this obviously cannot stand. But this analysis, albeit applied to claim notices in that case, of Parliament's intention as to procedural omissions and the party affected versus other parties, that all fits in with the part of the overall objective of this being a simple process to avoid obstruction by obstructed landlords. And therefore, one might expect Parliament to not intend obstructed landlords to be able to rely on the rights of the qualifying tenants to receive a NIP to obstruct the whole process, especially contrary to the wishes of the tenant concerned, as in this case. So, in my submission, you should conclude that the landlord is unable to rely on this procedural defect, if it is such a defect, and you should, in doing so, ultimately uphold the rights of Miss O'Connor, who wants this to proceed, and she is the person who, if we're wrong on the other issue, was entitled to receive the notice.
Yeah.
I think that's all I want to say on that issue, and then I'd want to go to the
Qualifying tenant issue.
Yes. Given the time,
Would you rather
have
break
any
and come
lunch
back
or-
at 5 to 2? And
it might be more
Yes.
sensible rather than saying
yes,
my opening
no, that
words
makes
and
sense.
then getting back.
So we'll stop now and start again at 5 to 2.